Yes.
7 p.m. next Thursday.
You-
Well, I'm not
What is-
actually the chair yet, you know, so
Listen. Welcome to the Goffstown Planning Board meeting of Thursday, May 13th, 2010. We'll go around the room and introduce those present, starting with you, Brian.
I'm Brian Rose, I'm the town planner.
Collis Adams. Phil Devanza.
Lowell Von Ruden.
Gail LeBrecq, recording secretary.
Alan Yeaton, Chair.
Barbara Griffin.
Tim Redmond.
Carl Foley, alternate.
And to get a full contingent of, we still have alternate, but when I step down, I have to recuse myself on one of these cases. Would you act as a voting member this evening, Carl?
Yes, it will. Apparently Jim is out too, so you'd be two.
Did he say he wasn't gonna be here?
Yes.
He's usually just late.
No, he's not gonna be here this evening. I'll start with the minutes of April 22nd, 2010. Action is required on the minutes. Any corrections, additions?
Motion to approve.
I'll second.
Motion by Phil, seconded by Lowell. Any discussion? All those in favor of approving the minutes, say aye.
Aye.
Opposed? Abstentions? Motion carries. Brian, I'll let you go to item number 2 under action items. A request for reconsideration of conditions on the approval for storm drainage tree removal. Can you give us a little update and what your conclusions are, Brian?
Mr. Chair, I'm looking in the audience and not seeing the applicant for the project at this time. I'm wondering if we can push this item a little bit later in the agenda so that they would be here to address any concerns that the board has.
Okay, let's go to item 3. It's out of order, but I entertain the request to continue the Fournier Revocable Trust Landscaping Site Plan to a unspecified June meeting, as recommended by the town planner. Tim?
Do we have a reason why they've asked to have this, extended, please?
Brian?
Mr. Chair and members of the board, the request did have some correspondence to you in an email. It was basically just to allow the applicant's engineer some additional time because the engineer had been out of town for a while and needed some additional time to be able to address some of the concerns that had come up on the planning board and conservation site walk that had been done about a month ago. And so rather than addressing the site plan without those issues addressed on their end, they wanted to push it back a little bit to have some more time to work on that.
And is that the date, June the 10th that they're asking for, or is that a question mark date?
Mr. Chair and members of the board, the date was not stated as their requested date. However, to move things along, my suggestion was June 10th. They had requested a meeting in June, so I went with the first one as my recommendation.
Well, it would be good to iron it out, because if people come to a June 10th meeting and they ask for another extension, at least people can come to the meetings when they're gonna be here. Maybe they could square that up with you between now and our next meeting.
But if we need to continue it, we need to give a date now.
Yeah.
Yes.
Yeah, we need to pick a date now.
A date needs to be decided so that the hearing can be continued and not have to be renoticed.
So should we be advised to maybe go the next meeting to give them the time they need, or do we push the issue? We don't
Well-
really know if they're gonna be ready or not.
We don't have anything scheduled for June 24th? Is from what I'm looking at?
Probably not at the moment, but this list is fast filling up. When I was talking to Brian and Patty today, there are some letters of interest and some other potential projects that are in the works. My question would be, is there any member of the board wish to see, after having a site walk and seeing a brief memo from the Conservation Commission. And any personal knowledge, is there any information we wish to convey to the proposer that would be a requirement for that public hearing? I.e. documentation, surveys, reports, Hollis.
I'd like to see documentation on the septic system and its current location, and has it been permitted there? That was one of the issues that came up.
I noticed in one of the other memos something about test pitting. Is there some request for additional test pits, and,
That's already been requested. I would expect that they would come forward with that information.
what about the contents of the plan submitted? Is the board wishing to hear the case based on, solely on the existing plan, or do they want something that represents what the property looked like before they did the work without permits?
Well, unless somebody has a dated signed survey of the property before, that would be all speculation anyways, so, or people's memory. I don't know that you can require a map based on that unless somebody has one.
You want,
Where
you want their
anybody went.
existing conditions based upon the town GIS? Which is a fairly accurate representation of topography and drainage and wetlands and whatever, as a place to start?
Well, they submitted a drawing, a topographical drawing with their drainage calculations, and it
Had the town topo.
has topo on it. That's in the packet from our original.
But that's a representation of the topography that exists there today, not what existed before modification to the property.
Okay.
Mr. Chair, we can always provide you the topo that exists on the town GIS as something to compare to if you would like.
Okay. That would be probably a good thing to have as part of the package, is that the pictorial with the topography on it, the aerial with the topography. Any other board members got any concerns about information they wish to have?
I mean, I'd like to see whatever historical information is out there that we can rely on to make a decision. For instance, I know that, and I have been on Google Earth, and you can view it, the photographs over time, and I would like some explanation as to how the fill and how the site has changed over time. And I think that's really one of the issues that we're trying to get a handle on.
Okay. Does anybody care to make that as part of a motion and as part of the continuance and the date certain to June, what, 13th or 10th? June 10th? Right, Tim?
Well, I think in light of this information that's being requested, we should advise the applicant of what we want and possibly move it to the 24th to give them time to respond and prepare their own side of the argument.
Yeah, I would agree.
Okay.
I'll make a motion that we continue this to June the 24th, and all the information that's been requested, the topography information and the septic system information, be provided to us at our next meeting.
And information relative to the historical filling and changes on the property over time, whatever that may be.
Okay, I'll add that to my motion.
Is there a second?
I'll second that.
It'd actually probably be better to, if we could get that in the mail package ahead of time rather than at the
Yeah.
meeting.
We have a motion and seconded. Continue until June 24th with some conditions for additional information. Any further discussion? I'll move the motion. All those in favor say aye.
Aye.
Opposed? Any abstentions? Motion carries. Do you want to go back to the number 2, Brian? I see Attorney Joyle in the background someplace back there.
Yes, Mr. Chair, that would be fine.
Okay, we got 4.5 minutes.
Okay, Mr. Chair, members of the board, this item before you is a request to reconsider a restriction of a 100-foot buffer on the Anna King Trust property they were given approval to remove any storm-damaged trees within their property outside of the 100-foot buffer. Applicant has been in discussion with staff and others, trying to come up with a good plan as to how to accomplish that, and in doing so, they've determined it would be too difficult for them to go out and remove any trees if they were restricted to that 100-foot buffer. Their request is to reduce that buffer to 50 feet. Some of the ideas that they, or reasons that they have are, and I'll just kind of get to this slide here that can detail that. Actually, let me back up. This is a map that was provided to you in your packets. It details out where an existing path was culled for tree removal a couple of years back, and as you can see, that does somewhat impact the vernal pool the 100-foot vernal pool buffers. Those are the dotted lines that surround the darkened pool lines that you can see in the center, and the marker line that you see on there is the path line that had been culled a few years ago. The applicant's hoping that in approving this request tonight that they would be able to utilize the same pathway to access most of the fallen trees that came down in the storm a couple of months ago. Their concerns are that they would be severely restricted to be able to access that site if they weren't allowed to use that that existing path, and that they would actually have to cut down additional trees to be able to create a new access path from a different area of the property. Also, the 100-foot buffer is where many of the trees fell, and so that restricts the number of trees that actually could be taken out off of the site.
Can I ask you a question? Brian, do you mind as we go through
No,
this? Can
go
you
ahead.
back up now?
Just a second. Based upon his presentation, I'd need a motion to reconsider before discussion.
So moved.
Second.
Any discussion on the motion? All those in favor say aye. Opposed? Tim opposed. Lowell opposed. Chair votes in the affirmative. Motion carries. So we are in a mode of reconsideration of this motion, and Carlos, you have the floor.
Brian, what does that mean when it says restrict number of trees that can be taken?
Just the fact that the 100-foot buffer contains many trees within that buffer, and so the amount of trees would be lessened if they could not take from
The amount
that
of fallen
from
trees.
the amount of fallen trees could not be
Okay.
taken because that would be more land area that has trees fallen on it that
And
could not be.
follow up, if I could, taken for what purpose? What does that mean, taken? Why do trees need to be taken?
Just removed and utilized for logging if possible. That's the reason why they're interested in taking them.
So do I understand correctly, they want to go in and take the fallen trees so that they can realize the timber value from the trees that have fallen? Is that what they're asking to do? Is that the reason for this?
I believe that is one of their main reasons,
Okay.
yes.
Tim?
Well, I'd like to say that this existing path, as shown here, impacts the buffer on all these vernal pools. We would not allow a new path to be constructed in that area. So if they have to make a new path to access the trees, because they do want to continue to forest the property, as I've heard the applicant represent. So maybe it is time for them to make a new path to get to what they need to get and to abandon this skidder trail that actually impacts the vernal pools. If that's one of the arguments for wanting to get in there. Make a new trail and start from scratch.
Lowell, you got any thoughts on this?
Yeah, one thought that occurred to me is that, a potential alternate access could be the location of the proposed road. If they're gonna turn it into a road anyway, could certainly access some of that area through that way.
Phil? Any comments at the moment?
Not at the moment.
Barbara?
No, nothing right now.
Then, seeing no additional comments, it's not a public hearing, per se. And, I would think the board's pleasure is to whether, either the applicant or other interested parties were able to speak on this issue.
Mr. Chair, if I may just make a couple more comments.
Okay.
Staff did have some concerns in reading some of the information that was provided by the applicant. They had spoken to and gotten a letter from, and this is copied in your packets, the county forester, and the county forester had stated that if the trees were left on the ground, then that would create what he quoted to be an unacceptable fire hazard. And so if a fire hazard did exist there, and if a fire did start there, it would destroy not only the habitats of one or two vernal pools, but would destroy it for all of them. Taking that into consideration, as well as the fact that it is a safety hazard to have leaning trees. There's been a few deaths in the past few months in southern New Hampshire from falling trees. Staff recommends that the 50-foot buffer be allowed, and that they be able to impact outside of the 50-foot buffer for taking trees.
Board members? Call us.
I don't buy any of that. I'm sorry, but I don't buy any of that. I don't buy the fact that 3 people have been killed by fallen trees in the last year or whatever. I mean, one guy was killed driving down Route 93 when a tree fell on his car. Good grief. That's just an absolute freak of nature that happens. That, to me, is no reason to relax the restrictions that were placed on this. When we approved this, and it was with agreement by the applicant that this was going to be a no-touch area. These are going to be buffers, they're going to be left as they are for all purposes. To suggest that it represents a fire hazard is beyond belief. I mean, there has been logging that
Okay.
occurred in there. There's slash that's been there. There's all kinds of debris in there. And I don't buy the fact that we need to relax our restrictions because of a perceived fire hazard. And that's my thoughts on this. I mean, again, when we negotiated, if you will, the approval of the subdivision plan, it was agreed upon by the applicant. Now to suggest that going in there and harvesting trees for whatever reason in an area that was supposed to be off limits, I'm sorry, I just can't accept that.
Barbara, you started to say something.
I didn't know whether we were gonna open this up for other comment or not, so I guess before I say anything, is the board gonna do that or not?
Chair hasn't recognized anybody in the audience, nor do we have a public hearing going on.
All right,
It'd be a recommendation of the board as to whether you wish to hear presentations from either applicant or other commissions.
well, I mean, I think I'm frankly okay without, I think, anything else. We have an extensive amount of material in here, including some correspondence from somebody from the EPA, and then we get into DES interpretation. And I have to tell you that my observation is that for some reason, this application is getting treated very differently, and I can't quite figure out what is going on with this board. I appreciate that there was a no-cut, and I don't think there are many people who were more pro or conservation than I am, and I appreciate that there was a buffer on vernal pools, which was recognized by the applicant as part of our ordinance when we approved this development. But that does not constitute a no trespassing sign.
And I think that's what this board has sort of taken the approach of, quite honestly. If you have driven by or walked that property or some other property in town that had this sort of, almost tornado or cyclone-like tree felling, it does occur throughout town where there are areas where large amounts of trees have been uprooted or snapped. And anybody who has any significant amount of property is gonna say they just don't buy the fire hazard thing. I mean, I don't get that. That's a huge argument nationally between Forest Services and conservationists as to whether forests should be able to be cleared out. Because there's some people who proffer that the reason forest fires are as large as they are is because forests do not get cleared out. So there is certainly correspondence from people who are involved in this, including the Hillsborough Cooperative Extension, where this board has gone to for a recommendation on cutting before, indicating that the clearing of the trees as proffered is reasonable. I don't quite understand the argument that we cut a new path when we didn't really want this site disturbed at all, or that we use the road to the lot to clear the felled trees when the roads to the lot doesn't come anywhere near the open space area where the majority of the trees have been felled, because that area tends to be the field area that's at the corner of Kennedy Hill and Shirley Hill. I didn't walk the property when they walked it, but I see in here that we're talking about removing down trees. And if you drive Shirley Hill and see this, and those are not in this area, if it's anything like has been represented as to what was seen on the walk, which included having to climb over downed trees, I can't imagine this board wouldn't want an applicant to be able to go in and clear out the site. This isn't like this is something the applicant did after the project was approved on purpose. And frankly, I think there's an argument as to whether the applicant needed to come in at all, because I think the no disturb zone has to do with the construction and development of the site. So I would just proffer to the board, I think there are some valid legal issues as to whether or not the restrictions as set forth in the development approval would even have applied to this. I understand Collis's position that this was negotiated. I'm not sure it was really negotiated. I think it was a condition, and when people went out and looked at the buffer, because I think there was an issue as to whether we were gonna require flagging, remember, to see if they could say it, because it wasn't. So apparently when they went out, they made a further determination. You know, I personally don't wanna see new roads cut. I don't know why you would wanna do that. So, given the material that I read in regards to what the observation was of the downed trees, I'm not really sure why there is such a large objection, because any homeowner who has that quantity of trees down on their property would want to remove them. I mean, that's just, you don't leave dead trees laying around. You cut them up and you get rid of them, and homeowners do it all the time. And I would suggest to the board that there are a number of properties around town doing that right now who just don't have pending applications before the board. So, I mean, I understand whether it's for profit or not. I mean, that's not our concern. I certainly agree with that. But what I'm hearing is the board putting its feet down and saying we set a 100-foot buffer and that's it. I don't get it. When this board has made all sorts of concessions for tree cutting and people doing things in all sorts of projects on other developments. These are not trees that the developer is now coming in and saying, I want to cut. These are trees that Mother Nature felled. At least that's every representation I'm getting from every piece of written material that I have received, is that these are not trees that are damaged as a result of any act on the landowner. And if I'm mistaken on that, then my position needs to be changed.
Carl, any input?
I was just gonna ask Brian, you walked the property, correct?
Yes, I did.
And what was your opinion as to the trees? Were they really impeding?
I had to climb over several trees just to walk through it.
And
It
they were
was-
trees that had fallen from the storm?
Yes.
Collis?
These vernal pools are all contained within the open space easement area. Okay, and correct me if I'm wrong, Brian, I mean, there's a 31.3 acre open space portion on this? Do we have a legal document that talks about what can occur and not occur in the open space, as we typically have with easements and those sorts of things? And would dictate what type of activities can occur?
Well,
within-
this board has a habit of approving forest management plans in accordance with best management practices,
I'm
so
asking, but I'm asking if we have a legal document
I don't-
that dictates the do's and don'ts within an easement area of the open space. And I don't know the answer to that, I'm asking the question.
I don't know as I have an answer to that question at the moment.
Because, and the reason I ask, because that would further lend support to the argument that you shouldn't be going in there. If the open space is intended to be left in its natural state without timber harvesting activities,
This isn't-
regardless of,
Okay.
I'm asking the question, Barbara. Is there a
I
document-
understand that,
Ladies
but I
and gentlemen,
think you're talking about this as a timber harvest, and I think the fact somebody's pulling wool, I mean, I suppose if you're
Barbara.
characterizing it for resale, that's why you're calling it that, okay. It's irrelevant.
Tim,
If I could just kind of clear up the discussion here, I remember the applicant saying that they were going to utilize the value of the timber to simply pay for the removal and the cleanup. They were not looking to go in there and run a timber operation. They were hoping that whatever they cleaned up was gonna help offset their cost to clean it up. And I think that's what the applicant represented.
that's correct. Phil,
I have no problem with the request, and I think staff did a good job on their research, and I think they have a reasonable recommendation, and if you don't mind, I'll just refer back to the letter from Mr. Mark Kern from the EPA. He says, what you are suggesting seems reasonable and consistent with the long-range goal of mostly keeping natural vegetation near the pools. While there may be some small, short-term impact, things should be fine long-term. And I think that's what we're looking at. We're looking at a natural disaster that nobody had anything to do with. The owner is trying to go in there and clean it up, eliminate fire hazards, just clean the property up, realize some possible income from the trees to pay for the cleanup. I don't think that's unreasonable.
okay. Limiting the discussion from the board, does the board wish to hear from the applicant or any other person before making a decision?
No.
If not, I'm gonna ask for a motion
Well-
in some fashion.
I'd like to hear from the Conservation Commission representative who's here in the audience, if the board chairman will allow it.
Not the chairman, it's the board.
May I ask?
Yes,
Chairman
Tim.
speaking on
If
behalf
we
of the
open it up
board.
to one group, do we have to then open it up to everyone?
We do
Board's
have a-
pleasure.
Well, we do
Just
have
don't wanna make this into a two-hour discussion, and we have so much else to do tonight.
I mean,
We could go on like this for all night.
there is a memo from the Conservation Commission at page 12 of the
Read 'em
mail
all.
package, yeah.
I read everything.
Yeah.
But I will not oppose you, Carlos, I just wanna be sure that,
I understand.
Then the chair will stand up and put both feet in mouth, and is there anybody in the audience wishing to speak in reference to this subject? Yes, ma'am.
Kimberly Peace, the Conservation Commission Chair. I will be brief. I just have a few points to cover. One, again, this is a very unique situation. We've never seen a parcel where we've had this many unique vernal pools. Secondly, Lowell is exactly correct. In the conservation easement language, it was allowed to have timber management with an approved timber management plan. That hopefully means there, and then in that easement, there is a 100-foot restriction around these pools. So the applicant in future logging or timbering efforts will need to take that into consideration. Third, this is an open space area. It's preserved for its ecological value. I'm confused as to the concern regarding a safety hazard when it's an ecologically based parcel, and I understand. I was out there with Brian and we saw bike trails out there, but that's a trespass issue. That's not, I would argue against the concern to remove the trees as a safety hazard because there are no people out there, and if there's trespassing going on, that's, it's just counter to the goals of an open space easement. It's an open space area, and it needs the protection. Conservation is also concerned because we're sort of left out of the loop of the correspondence of this, and we're surprised to see the staff's recommendations, and, have been working on this, and, that's all I'd say.
Okay. Having opened it up to, yourself, is, Public Works have any comments?
Oh, I was not involved, some early correspondence.
Does the applicant wish to speak for less than 5 minutes?
I almost don't dare to say anything.
I'm a lawyer, so I'm going to anyway.
Our intention is in fact to protect the vernal pool, not to affect them negatively. In fact, before the board.
Pardon me.
I'll just hold on to that for you.
Before I had ever met with any of you, and we had gone in there to cull some of the wood lot 2 years ago, we applied these best management practices on our own voluntarily. And we made great effort to avoid doing anything that would harm what was characterized as vernal pools by us, not by the Conservation Commission or anyone else who was concerned about it. And again, in this instance, there's no real effect on the vernal pools, except to the extent that there are some rather large trees that have fallen into them. And what we're going to do is cut off the end of the tree outside the 50-foot buffer and not affect the pool itself. So we won't be dragging trees out of the vernal pools, and we won't be cutting new trees. We're not gonna do any harm. We're gonna try to clean up the mess, as I said, and I wanted to clarify that this is not a for-profit operation. And my great concern is that there won't be enough harvestable lumber from the cleanup to pay for the cost, because it's a very expensive undertaking. And I wouldn't have looked for, and wasn't expecting, and I don't think anyone would prefer to have had happen what did happen. And there's more than just the trees out around the vernal pools, you know. They're along Sherwood Hill Road, and even in the backyard, I guess you'd call it the dooryard of the house, there are sprung trees that you need heavy equipment to deal with. You can't just cut them. They're too big, they're too heavy, and they're too dangerous. But it's very costly to deal with 3 trees with the kind of equipment it takes if you can't offer something in return to pay for it. Beyond that, there are no surprises. There's nothing new. Not gonna hurt any frogs, and we're not gonna hurt any salamanders. Thank you.
You've got it.
Thank you. Hearing, anybody else wishing to speak? I'll close it to public comment, please. Back to the board, yes.
I'm encouraged to hear some of the things that I'm hearing now about cutting them and leaving the parts that are within the vernal pools. Is that spelled out somewhere in the management plan?
Yes, it is,
It is?
yes,
Yeah.
For this
It says-
specific,
yes,
for this specific
Yeah,
harvest?
they said
Yes, it is.
they're doing nothing within 50
Okay, I'm
feet.
just asking the question.
okay. Giving the answer to that question and the testimony that we've heard and the discussions we've had, I would entertain a motion that backs the recommendations of the planning board.
I'll make a motion that
Executive.
we accept the recommendation of,
There's a second to that motion,
second.
seconded by Mr. Foley. Any discussion on the motion? Hearing none, I'll call the motion. All those in favor say aye. Opposed? Abstentions? It's unanimous, the chair votes yes also.
I'd like to note for the record, we used a tree for the paperwork.
No. 1.5 trees.
Okay.
Moving on in our agenda, we're gonna go into our regular scheduled hearings. And item number 1 is map 17, lot 237-1, time extension request, and the chair is stepping down. And our vice chair, Tim Redmond, will oversee our proceedings. Tim? I'm gonna remain in my seat, but quiet.
Okay, this, I'm gonna wing this because I haven't done it before. This is for map 17, lot 237-1 in the industrial zone. Location is Laurier Street. The applicant is requesting a one-year extension for the time allowed to begin construction of an approved and signed site plan. First thing I'll need is I'll accept a motion to find the site plan extension request does not have a regional impact.
I'll make that motion.
Second?
Second.
Motion's been made and seconded. All those in favor say aye.
Aye.
Those opposed? Motion passes. I also need a motion to accept the site plan extension proposal as complete and ready for review.
So moved.
Second.
All those in favor?
Aye.
Aye.
All those opposed? So moved. Brian, do you have anything for us before we get the applicant's presentation?
Just a brief introduction to the project. I'm sure many of you remember this project because it was approved just recently, back on April 24th, 2008. I'm sorry, approved on May 22nd, 2008. From that point in time, the applicant has gone forward and gotten the plan approved and signed. That was approved and signed on May 14th, 2009, approximately 1 year ago from today. They're here just for an extension because they have not had enough time due to the economy and the condition of the economy, that they have not been able to move forward with building any units at this time. So that's basically the request. You can see the map on the wall here. This is the location of the project. It's in an industrial zone. It's close to the Manchester border between Goffstown and Manchester, just north of Mast Road. This is the site plan that was drawn and approved. And then these are the elevations for the building. It's a 4-unit building. And there's some more elevations. So the request is to extend it for 1 year. There's been no negative comment by the public. This is the first extension request that has been submitted by the applicant. And the recommended extension date would be May 14th, 2011. Staff recommends that the extension be approved.
Are you aware of any changes to our planning or zoning regulations that might have an effect on this extension in relation to this project?
No, Mr. Chair, I'm not.
Okay. Thank you, Brian. Is the applicant here? Would you like to speak?
No.
No? That's good. Thank you. Okay, so we can open a public hearing right now. If any of the public has any comments on this application to have this, for this extension. Anybody from the public wish to speak? Great. Public hearing is closed. Board members, would you like to discuss this amongst ourselves?
I'll make a motion to approve the request for the extension.
I'm sorry, Meg?
I just wanted to add.
I'm sorry, Meg. I didn't mean to go pass you by.
No, it's all right. Just for the record, the town is paving that road this year. We were actually going to be paving it, I believe, 2 years ago, right after this was approved. And we held off 2 years ago and last year, I believe, because we knew this was possibly coming down the pipeline. And they have some work to do, some tie-ins into the road. And once we pave, the road is under a 3-year moratorium. They still can do their work, it's just gonna be more costly. They have to overlay any trench work they do 100 feet full width pavement. And we've already waited 2 years, so I've been told we are moving forward. We actually have some drainage work to do, and I believe it's scheduled for June.
Has the applicant been formally notified of these events? Or
We notified him
in-
a while ago when we were planning on paving. I don't believe we had notified him this year that we were definitely going through with it. I'd have to look back, but I don't know if it was Mike or I know we had both talked, and the again, we had held off because we were thinking this might be happening, and I think they did too, but then just haven't moved forward, so.
All right, well, I'm going to, applicant obviously wants to speak at this point. I don't know that it's gonna affect our decision
Yeah, I'm just
tonight,
waiting for the.
whether you folks work things out or not, it's gonna be between you. It's not gonna be anything that we're gonna decide tonight, so, if you would like to speak, welcome to. And identify yourself for the record,
Yeah,
please.
Don Lavasser is the owner of the property. I was told also just recently that, now we have to have a sprinkler system, so we have to have a review of our plan and water, the entrance to the water, make sure it's the right size and stuff
All
like
right,
that.
well, that's, you'll
And
have,
I'd be glad to put it off the lot, actually, to get started. It wouldn't bother us to do that right now, if it's gonna, if we're allowed to do that.
well, that's between you and Public Works.
Okay.
Your extension, the vote tonight as to whether to give you an extension or not.
Okay.
If you wanna do, on or off-site improvements, that would be between you and Public Works and
Okay.
bonding and whatever else is
It would
involved with
have
that.
to happen very soon, like a street opening, I mean, we have a
Well-
permit process for that.
We'll let you folks deal with the applicant on that. All right? Thank you for that. All right, we're back to, we started with a motion. You have a question, Barbara?
Yeah, just, I'm looking at the conditions, and I understand the plan has gone forward and been approved. Has the Sewer Commission and Manchester Waterworks approved this?
Yeah.
You've got that?
Yeah.
Okay. All right, so you understand what Megan said about the road and all the tie-ins need to be done, or else you're paying for that section of a new road when you do it?
Yeah, I'll call her in the morning, make sure that it's all right, and get it squared away.
Good.
so we can do that. Yeah.
Thank you for that, Meg. I'm sure they're happy you told them. All right, there's a
Second
motion by Collis to approve the extension. Who seconded it? Phil seconded the motion. Is there any discussion on the motion? Hearing none, we'll call a vote. All those in favor of approving a one-year extension to May 14th, 2011, say aye.
Aye.
Opposed? Chair votes in the affirmative. You're all set.
Thank you.
I'll
Thank you,
turn the
Tim.
meeting back over to the chairman,
Thank you. Well done.
because that was easy.
Moving on to the next item on the agenda. Map 4, Lot 87-3 and 77, final subdivision review hearing for a proposed lot consolidation and 3-lot subdivision, Thomas Lally Revocable Trust, Lesney Road and Checkerberry Lane, zoned R1, and Wetland and Surface Water Conservation District overlay, continued from April 8th, so the meeting and public hearing is still open. Mr. Todd, you have the floor.
Thank you, Mr. Chairman.
But I think probably Brian has a few words of wisdom that he can like to say first. Is that okay?
Absolutely.
All right.
Mr. Chair and members of the board, this project was just before you recently, on the 8th of April. At that meeting, you decided to continue the project to be able to allow for a few additional items to be completed by the applicant, and also to request that some additional design work be done on the driveway. Just for the public's information, I've got some maps up here that everyone can see. This is the location of the property. It's located on Lesnick Road and Checkerberry Lane on the northwest corner. This is the site plan. The site plan is for 3 total lots, 1 existing house and 2 additional lots. It's on approximately 10.3 acres. And the applicant has submitted revised driveway plans. They do meet the town's requirements for fire trucks and turnaround. Staff did look into the turnaround requirements and found that it was a 16-foot maximum width, or minimum width, I'm sorry, and that included a 2-foot shoulder on both sides. So really they can go to a 12-foot driveway with 2-foot shoulder on each side, giving them a maximum, a minimum clear zone of 16 feet. No, there was a minimum clear zone of 20 feet in addition to that, but the paved and shoulder was 16 feet. So, engineering's gone through their review of the project. They've made some comments and conditions on the report, and then planning has no additional comments. We've received their easements from the applicant, and those will be still subject to town attorney review and approval. There was one item that Megan brought up to me just today, and that was that there are some outstanding fees that still need to be received by the town. So before final approval, we would request a condition that all outstanding engineering review fees shall be paid to the town. Is that? Other than that, staff recommends approval of the subdivision, subject to the conditions that are stated in your report and that additional condition regarding fees.
Did I see an email come across my desk about some condition on the easements?
Mm-hmm.
Was there from one of our members, was there a question about easements? Or some particular paragraph be added to ensure that the town had access to inspect the drainage and the driveway since it was part of some kind of easement? That the wording should be added. That was something that came into my office late today from Jim Norman,
Oh, from Jim Raymond?
from Jim Raymond.
Mr. Chair, if you would like, I can read what he emailed.
I don't necessarily, just give us the gist. I don't need to read all
Yeah,
that.
well, let me know, because I have some comments too, so let me know what he said. On what document we're talking about.
Mr. Chair, I'm just gonna read it because I don't remember myself.
Okay,
It states, "The Lally documents give the town the right to enter onto the property to make repairs. I would also like to see a right to enter to inspect the drainage structures, which can be at reasonable times and on reasonable notice." And he gives reasoning why he's requesting that, but I don't know that that's necessary. Do you want to hear the reasoning why?
Nope. It's just that without that in the easement, you have to stand on the property line to do your inspections.
Right,
Because
we're
you have
talking.
no right of access.
Yeah, Mr. Chair.
So we can discuss that as we get in there.
Okay,
But
all right.
that's all the correspondence that I know of at the moment. I think there are a couple other letters we'll talk about later. I'd like to turn it over to Mr. Todd for a presentation.
Well, I really don't think I need to say anything. Mr. Rose has covered just about every issue that I was gonna speak about. The one thing that he didn't mention was Megan's review of the drainage report. So maybe she could brief the board on her thoughts on that. And I do have some plan edits, I think, that will be good for the board to see that you haven't seen. So when she gets through enlightening us on the drainage report, then we can talk about some plan edits.
All right, members of the board, any particular discussions? Why don't you just have a seat right there and relax for a second? Members of the board, any questions or concerns, comments?
Comments.
Barbara?
On documents, Brian, one of the documents was waiver of municipal liability for shared driveway.
Yes.
I'm assuming this is a recorded document. If it is, it needs to be in the proper form, just so you know. It needs 3 inches on the top. We need some certification of signatures. The other documents were all set up like that, so I wasn't sure where this came from, but it runs to the other lots, all the lots, so it needs to get recorded.
Okay.
The other documents that were prepared, that Mr. Lally signed are all, notarized in 3 inches. I believe the document that Jim Raymond was referring to was the Declaration of Covenants and Easement. in regards to the trust, he was referring to Article 3. I have a comment on Article 1. And this may go to Megan Moore. And the CO process in regards to the correct installation of the basins, being a professional engineer or CPSC person. It sort of doesn't say what is supposed to happen with that, it just sort of says it's supposed to be done. So you probably need to add that it needs to be submitted to the town and approved, because there's actually no requirement for them to do other than to come in and say it's been done. So that there'd be something then on record with somebody's certification as to how it was done in your file on the lot. In Article 3, on page 2, I did circle it because it does provide only for access in the event of failure. So Jim Raymond's comment was we need to, this is where, actually Article 2 as to maintenance is where the provision should probably be added to allow the town to access, to ensure that maintenance is being performed. And in the event the town determines they're a failure, then Article 3 kicks in.
Okay.
The other question I had for legal counsel when this gets reviewed is to really how we're talking about assessing the owners, and this is the never-ending problem with these agreements. It says, shall then assess the owner or owners as the case may be. Okay. Assess them what? In the same manner as imposing a lien for unpaid real estate. I think the language as it's presented actually says you can assess them, but doesn't provide for what. And then says, once you've determined whatever this assessment is, you follow the same manner would refer to the process that a tax lien is recorded. A tax lien is actually determined by other statutory authority. That wouldn't be, I mean, it's a good document, it was just that it really didn't tell you where to go or how to go. If you're gonna, cause my guess is that these can be pretty expensive to maintain if they fail. I mean, I don't know anything about them, they're new really for all of us. So anyways, those two provisions need to get looked at. And Exhibit A is attached to this. I didn't find a reference to Exhibit A anywhere. Okay, I'm not sure it needs to be there.
Probably the detailed maintenance of
It
the
is,
building.
it is.
Oh, you have it? Okay, I didn't have it.
The bioretention operation.
Yeah, I asked for that, 'cause that's,
That may be more for information for us, since it's one of the first ones we've seen, rather than something that's gonna get recorded.
It's gonna get recorded,
That
Okay.
Exhibit A?
yes.
Okay, fine. Well, I'm not
All right.
paying for it.
Well, then, I would suggest that Article 2 needs to refer to in accordance with the process and procedures as set forth at Exhibit A,
Okay.
as modified from time to time. I think that's what we do with the statutes, right?
I think so.
So those are my comments on the docs, thank you.
Thank you. Tim, anything? Carl? Lowell? Bill?
Mine have all been addressed in the documents.
Collis?
That's good.
Chair has no particular questions at the moment. There are a couple of letters that the board has received from a butter, a Tiffany H. Negro. It talks about she's the abutter to the north on Checkaberry. I believe she's a property owner. I'm not sure that she lives there, but she is the property owner. We take those into considerations, and we received a mailing today from one of the other abutters requesting us to consider in our decision-making process, this was John Peltonen, that we, all declarations and agreements be recorded in the Registry of Deeds, which we plan to do. Approval should condition on compliance with every regulation known to man. And, number 3, since water management is critical, no further subdivision would be permitted, and a no-cut provision should be added to that existing trees are able to take up water. That would be all something that, is in the record, be attached to the record, at this time, and if
That's gonna be hard to.
you don't have it in your packet, it's a copy here if you wish to read it before any consideration. Now, the public hearing is still open. Are there any boards and commissions wishing to speak? Public Works?
Do you have any specific
Do you have specific questions
questions or you want?
or comments? You wanna take us and educate us at all about anything?
I reviewed the plans, you know, I had some minor, notes for the different sheets, reviewed the drainage, and it appears, you know, the rain gardens are properly sized for a 10-year storm, which is what's recommended in the new, stormwater manual. The little small infiltration basins or detention basins that are along the front, appear to hold water even up to a 100-year storm. I mean, they don't take a lot, they really only take half the driveway size, so they're more than large enough to handle the water. Overall, the site has a decrease in water, but again, that, we don't really take that into consideration. We look at each point that water leaves the property, so point A, B, C. And, although there's an overall slight decrease, there is also a slight increase in the northeast corner, which is to, an existing wetland area. And we had talked about this before. I mean, these, rain gardens are more to treat the first flush of water. They're intended more as a treatment practice, I think, than a storage practice. I mean, they do infiltrate for smaller storms, but, one of the concerns that we look at in larger subdivisions is on bigger storm events, is their storage capacity. And those rain gardens are really not designed to have a lot of storage capacity. So I kind of am looking at this differently, where on a bigger subdivision, we don't allow any increase, like nothing. But when we get to a small 2-lot subdivision, we're usually not getting this detailed in drainage design. We have gotten very detailed, and I've looked at it all, and, you know, I'm being honest that there is a very small increase to the northeast corner, but it's minimal, and I don't think it's anything we would ever require them to store every ounce of water in such a small subdivision. And that's up to the board, but that's how we've kind of done our practice in the past. I think for a 2-lot subdivision, they've provided several drainage features, and with the hopes that the maintenance is kept on those, it should be fine.
Thank you. This public hearing is still open. Are there any members of the public wishing to speak in reference to this particular project with new information, not information we've heard prior to this meeting? Yes.
I'd like to address the board and show some presentation pieces.
And your name?
My name is Catherine Prozkaza. I'm a neighbor to the north. And the last time that I was here, I was talking about the archaeological aspects that exist on that site. There are antique, historical, essentially antique dumping sites of materials that were used on some of those older houses uphill that were originally subdivided into this property that as it exists now. Those are located where the homes are going to be built, where they're proposed to be built. The last time I was here, on the 8th, I was concerned about it, and I made mention of it, and I said that I believed that it needed to be reviewed by the Division of Historical Resources. Mr. Todd responded that the bottles were likely his grandfather's beer bottles, and he said that they were not necessary.
Ms. Prozkaza,
That's what he said.
no
That's what
personal
he said.
references, please.
That's what he said. Now, I did some research and I found that the Section 106 of the National Historic Preservation Act stipulates that any project with federal involvement, which includes funding, licensing, permitting, etc., must be reviewed by the State Historical Preservation Office. In New Hampshire, that is New Hampshire Division of Historic Resources at 19 Pillsbury Street. in Concord. New Hampshire also has RSA 227C9, which mirrors the federal section 108 and requires that all agencies are to cooperate with the Division of Historical Resources in order to protect natural and historic resources, which include archaeological information. I have an email from Christina St. Louis, who is the Review and Compliance Program Specialist, and she writes, we have never received this project, and we should have. Under general conditions of number 8 of the DES permit, which you have attached, they are instructed to coordinate with Division of Historical Resources. And it reads, under the wetland permit, which is the wetland permit and non-site specific permit 2008-00927, general conditions that apply, item number 8 reads, the permittee shall coordinate with the New Hampshire Division of Historic Resources to assess and mitigate the project's effect on historical resources. She specifically said that this is under their purview. They have archaeological professionals that will come out and analyze the site and see and determine whether there is or is not a historical or archaeological value to the sites that are out there. I went with my neighbor this afternoon and we walked around, and there are many locations where there are rocks in circular patterns covering things. I don't have the materials to unearth those things. I don't know if they're antique bottles or what they are. But it's not my determination. According to state law, it has to be reviewed by the by the Historic Commission at the state level on Phillipsburg Street. So, because those sites exist on the site before any of us were here, those sites need to be identified and mapped, and the site for the homes need to be identified as to make sure that they don't interfere with those. And I have a specific concern about this because I'm downhill from this site, and my water is surface water on a dug well. So if they do unearth whatever it is, and it runs downhill into my property, it's going to contaminate my well. This is not an insignificant issue. This is a state law issue, and to approve this before those things are mapped and identified and shown that they're not going to create a negative impact for the abutters, this project cannot be approved. This is not a case where you can conditionally approve something on something. There's real stuff. You've gotta see where that is and make sure it's not gonna create a problem for the abutters. Thank you very much.
Do you have any correspondence, written reports, or otherwise from the state backing up your testimony?
I have emails right here.
Specific as to that particular property in regards to what the state has found, or responses to your emails as to what you have found?
They are specific related to this project and the wetland permit, and this wetland permit is specific to the site, to what the wetland permit requires.
I
So
understood
that's
the reference
specific
to
to the site,
paragraph 8, okay,
and then
which is
I-
typical to every DES permit,
Correct.
as I understand,
That's right, that's right.
Okay, just so I
Yep.
understand.
And then I spoke with her and I told her about these bottles, and I said that we were concerned about that, and she said absolutely, that needs to be reviewed. And in addition to that, the fact that it requires the review of the wetland permit, item number 8.
I understand the link between the two.
Okay.
Okay, thank you.
Right.
You answered my question. Thanks.
Thank you.
Do you wish to submit anything to the board?
Would you like a copy of this?
You present it to the chair, become matter of the record.
Okay, these are reasonable facsimiles. I didn't have the bottles when I was gathering the information from my, these are the actual bottles. These were, here's the wetland permit, and here's my email that talks about very clearly, she says, we have never received this project, and we should have, under general conditions 8. So, yeah.
Have you retained copies of those for
I
yourself?
will give them to Gail. Who gets them?
Actually, give them to me, and
Thank
I'll make them a matter of record. During the process of continuing this presentation, are there any other members of the public who wish to speak about this project? Yes, ma'am. Please state your name, please.
Barbara Lally.
Yes, ma'am.
I believe that you are a butter, on the other side, no, of Checkberry Lane.
Address the board, not the.
Excuse,
Direct abutter to the property.
ma'am, do you have something you wish to present to the board or comment?
No, I made a comment that this person who just made this presentation before is not an abutter to the property.
We understand that.
Okay.
Thank you, ma'am. Any members of the board wish to read this while we're?
Mr. Chair, Mr.
let
Lally
me
has got his hand up.
Yes, sir.
I think she's told us before that her well has been contaminated by a person, a house across the street from her. How he's gonna ever divine that something's coming from our place? I've been looking for stuff for years, and the field in back of my house was cleared, and there's rock dumps down there. They dumped them at the end of the, you know, and the trees beyond that are beech, meaning, you know, they're very, very old, so the field had to stop before they get to those beech trees. And I don't find the complaint very convincing, and furthermore, I don't know if somebody's supposed to go on your property without permission. And the stuff she wrapped up, I suppose, is our property. Anyway, this is getting preposterous. It's gone on for a year and a half. We spent $70,000 or $80,000 on this. You get calls at the last minute before we come to meet with you about new engineering studies that need to be done, and it's not an isolated event. This happened over and over and over again, so the planning process is not too hot as far as I'm concerned. And well, anyway, nobody should be treated this way.
I understand your concern, sir. Speaking as the chair only. Now, members of the board, any questions of presenters or otherwise?
Just one observation and comment.
Yes, sir.
When you look at the entirety of the email from DHR, what wasn't pointed out was that she says, unfortunately, we have no real power to force them to comply, and that's an accurate statement. So you need to look at the whole response from DHR.
That's why I asked for the members of the board to read the correspondence. Carl, anything? Tim? Barbara?
No.
Lowell? Phil? Collis? Mr. Todd?
Okay, well, more to the drainage issue, if I may.
Yes, sir.
If you go to sheet 4, 6, and you won't see what I'm edited on the map that you have. However, you will see what I did present, and we'll try to explain what I'm proposing. And if you want to make it a condition of approval, I think that'd be all right with the client, and certainly all right with me. When we submitted our application and the maps that support that application, I used a test pit that had been dug for a previous concept to put a septic system on to serve this house. So I ran the line down to this point, which would have caused quite a lot of extra clearing of the forest. And so now we're thinking, because this easterly sub-catchment area has an increased flow as a result of the development, we could do something on this lot to help mitigate that increased volume or increased volume of runoff by moving the septic system location to here and just clearing this much of the lot. And we will save 9,000 square feet of forest and put the septic system in a more economically feasible location, which probably would have happened anyway, but if the board wanted to make this as a condition and help me cut down on the amount of clearing of the forest, that would certainly be all right. I don't think it would have an adverse effect on the saleability of the lot or the function of the lot or the attractiveness of the lot. In fact, it might even be more attractive with more trees on it than not. So that speaks to my response to the drainage study.
Tim?
Mr. Todd, I have a question then. If you're going to have a bio garden that's gonna recharge the ground with water, how about the proximity of the bio retention area to the septic system? In other words, you're trying to, I would think you'd wanna consider that the bio retention area would not infiltrate the septic bed, is what I'm getting at.
Well, if you look at the contours, the groundwater flows downhill like water on the surface. This is outside the limits of the flow path of either of these rain gardens. So, and we are more than 35 feet away.
Is the septic a
75
raised,
feet away.
is the septic a raised area or is it in-ground area, do you know?
It is a raised system, yes.
So that would also help keep it away from it. If it's higher than the original contours, and that
Right.
rain garden's gonna go into the original contours. Okay, thank you.
Members of the board, you have any other questions of Mr. Todd? Thank you.
We've pretty much gone over the outline that I had.
Yes,
I
sir.
did, I have a question for the board, or through you, Mr. Chairman. It's been a little bit discouraging to have, having submitted our paperwork on the 28th of April, and then not get responses from staff and so forth until this afternoon. What can my office do to help speed up the response? Do I have to get it in more than 3 weeks in advance, or how are we gonna do this? It seems that when I submitted everything on the 28th of April, I had like 14 copies of the documents, and then in corresponding with Megan, it seems that she didn't have those documents. I'm wondering, is she left out of the loop somehow, and we have to communicate with her directly?
We'll take that into consideration,
Yeah,
Mr. Todd.
Chair, I think
Wow,
I think this is a little off base for our discussion.
Yes.
almost completely off this application now.
The,
Well, let me just wrap up by saying that I think that Megan and most of the members of the board perhaps would agree that we have reached the nexus of having a completed application and having something that you can approve conditionally. I think that the wording of the terms and provisions in the documents can be worked out relatively soon. I don't believe there'll be a lot of changes on the plan. We have addressed the edits that Megan had, and I'm gonna send her copies, and they were minor. So I would ask that you please give us a conditional approval The issue that, the non-abutter brought up, I think, is at the state level. We haven't got subdivision approval for this, and you generally give your, plans and applications conditional approval, and state permits are one of those conditions. So if there has to be a review by DHR, then so be it. That'll be part of the process on the state level. That's the only pleading I have. Thank you very much.
Thank you. Public hearing is still open. Does the board wish to hear any further comments from the public?
We have everything.
Excuse me? I'm gonna take a look. You got one comment, Madame.
Thank you, Mr. Chairman. I just wanna say that, in regard to the board has the authority to require the historic review and has the obligation to require that, according to the state law. They Chris said that they don't have, the right to enforce the rules. You have the requirement, according to state law, to make sure that they do their review. So there's no, is it required or is it not required, and do they have jurisdiction, and do they have, I'm missing the word that I'm looking for, the enforcement of that law. They said that that's verbally, she's told me that is this board's purview and responsibility to make sure that they, do have those reviews according to state laws and federal laws, and it's your responsibility to make sure that happens. So the enforcement, that she says in the note that they don't have the capability for enforcement, but you do have the responsibility to make sure that it happens. Also, a question about the 100-foot setbacks on those rainwater retention and the wetland area to the north of the site. That property immediately to the north of the site where additional water will come off, where Mr. Todd says that water will come off, there's an in-ground pool right there, and they have a substantial problem with water running off of the mountain now. If there's going to be additional water run off at that point, and you're within 100 feet of the wetlands, there is a compounded problem on top of an already existing problem. So I would recommend that you think long and hard about allowing more additional water to run off onto that abutter's property, because it is a problem right now. It is, plain and simple. And if rainwater and water is going to be recharged into these rain gardens. The rain gardens are a great idea given a natural environment and a natural contaminated soil, but to put water in contaminated soil is a problem, and to charge it into where people are getting their drinking water from is a problem. You have seen evidence that you know that this problem exists. To not take that into consideration in a significant way would be remiss by not making sure that happens before you granted approval. Thank you very much.
Thank you. Upon hearing that, I'm going to close the public hearing. Now, does the board pleasure to consider this at present time, or do you want to consider it at the end of our meeting?
Consider it right now.
Okay. We have before us, and we should start with, does any member of the board have a question or comment they wish to make reference this project? Collis?
Well, maybe for the enlightenment of the board, I can talk a little bit about the Section 106 process and how it fits in here.
What's section 106?
That's the historical resources
Okay, thank you.
issue that we're talking about. That is only invoked when there's a federal license involved. In this case, the federal license is the wetlands permit. That is a federal license. 106 is a federal requirement. What the statute, DHR statute says, is that other state agencies will cooperate with DHR in furthering their goals. DES does that by requiring the applicants to certify on their application for a permit that they have provided materials to DHR for their review, so that DHR can take the responsibility of doing whatever it is they need to do to protect the resource that they're charged with protecting under their state laws. We've done that. The applicant sometimes does that and sometimes does not do that, but when they sign the application, they're certifying that they have submitted the materials to DHR. Now, we know from experience that doesn't always happen, but the fact remains, DHR is notified by DES that we have an application, and if the applicant in fact says they are submitting the material to DHR, but they don't, it's DHR's responsibility to go after the applicant and get that information so that they can perform their review. And so DES' position is we have complied with the statute as far as cooperating with DHR so that they can move forward with their mandate. So just to give you an idea of how that whole thing works. So the applicant says, yes, we provided to DHR. DHR says, we didn't get it. DES has said, well then, it's your responsibility to go out and get the information. And DHR, to be quite honest with you, they don't have administrative rules. They don't have a process set up whereby they can do this. And they're trying to piggyback on DES just to give you a picture of how this whole thing is shaken out, how the process works.
Tim?
So the only way DHR could get and evaluate information would be if someone was to come forward and say there is something on this land, because they couldn't possibly go to every subdivision in the state and walk the property looking for artifacts.
Yeah, true.
So they basically act on complaints only rather than
Well, no, they're
proactive.
alerted to the fact that we have an application in. They know where the property is, they know the tax map and lot number, they know exactly where the property is.
Mhm.
Now, they can either choose to jump into the fray
Or
or
not.
not.
Okay.
But DES has maintained, we're not gonna carry that monkey on our back.
Right.
We don't have the resources to do it. If you wanna do it, you adopt administrative rules, you staff up, you get funding to implement some sort of program, and you take on the responsibility.
So
And
where are,
we'll continue to assist you with that by notifying you of projects as they come in.
So we're in the same place here
I
that
say,
we
so
are
in
in
your,
everybody.
in your
That's
opinion, Carlos, where are we with the application right now with this new material? Are we obligated to have the applicant notify DHR, or are we
No,
just
I-
pass it on and let the state agencies do their job?
I'd say we put the standard condition on, you have to comply with all other local, state, and federal regulations.
Okay.
Period.
Fine.
Phil? Lowell? Barbara? Tim? Corey? What's the board's prerogative?
Just because you broke the chair.
Yeah, probably.
Carl? Excuse me. I'm too many people. Yes, Barbara?
Chair, well, I understand that staff on page 43 of our packet made a number of recommendations in regards to conditions of approval. And I would note that in regards to my review of those conditions, as to both 5 and 6, that in addition to the language proposed by our planner, that the language essentially and in accordance with the comments of the meeting and the review of town's attorney on both 5 and 6.
Okay.
And I believe that we would want to add a condition, that all outstanding fees be paid. And in regards to approvals, I understand that there's a condition subsequent, and I would assume that any approval, both preceding and subsequent, would be subject to all state and local regulations.
What about number 3 from the memo?
There has been an abutter request in regards to no-cut provisions for the existing trees. And I have to admit, I'm not really sure how you would even address that.
And no further subdivision he's asking for as well.
Yeah, it's been pointed out, it also requests no further subdivision of this parcel, which I think should also be on there. But I don't know if the board wants to discuss the issue of the no cut. It's sort of, I don't really know. We're not talking open space here, we're not talking.
These are people are gonna buy these lots, have to have the right to cut their trees in their own backyard if they wanna build a pool or for whatever reason. I mean, you don't wanna let them clear cut their yards, obviously, but I don't think we can provide a provision that they are not allowed to cut trees on their own land.
Okay.
I have a question, Alan. For
Just
Mr. Todd.
one?
This is for Mr. Todd.
You can't question Mr. Todd.
I
You
can't?
Question the chair.
Okay, I'll question you then. What happens to the, these lots? We have lot 87-3, and then we also have the lot 77. Now, 87-3 has become part of the access to the other two lots. Does 87-3 go away? How does that all work out?
My recommendation would be that part of your motion would say that, from this point forward, these two separate tax parcels would be consolidated as one lot.
But does that require a
doesn't-
lot line adjustment deal or something?
Well, that's why I say you could put that into your motion, that's what I
Well,
thought this would be done originally.
We should have, I mean, it should have been picked up on, I think, a little sooner than right now.
I think what the title of the plan is lot consolidation and re-subdivision is the technical term.
So,
And so the assessor's gonna say,
Right. The assessor's
it-
office would.
it's subdividing, there's 3 lots, he's gonna give them 3 tax identifications, amen.
so the 87-3 just disappears completely and it becomes 3 lots?
Yes?
Okay, just as long as I understood what was going on.
Yeah, if you read the documents, you had to sort of follow the lot
I'm not a
references. It was
lawyer,
a
I can't
little,
read 'em all.
well, it was numbers.
Was that a motion?
That was the
I'm
motion.
gonna ask her,
Oh,
she made it in the form of a motion, and she made some amendments to that motion,
I'll second the
of
motion.
which have been duly recorded by our secretary, and I'm looking for a second for
I'll second.
approval. That's a motion for approval.
It is.
I'll second it if Phil hasn't already, I don't care.
Don't fight. Tim first.
I'll second
Seconded
it.
by Tim. There's a motion for approval on the floor with conditions as stipulated by the proposer.
We have all the conditions correct, right?
Yes. Duly noted, and we will have a chance to reflect on those in the upcoming minutes.
That's also gonna be subject to those changes you discussed.
Right, I said in
Subject
accordance.
to her
Wanna
changes.
make sure.
They were added, right.
The motion has been made and seconded for approval. Any further discussion? I'll call the motion. All those in favor say aye.
Aye.
Opposed? Abstentions? Chair votes in the affirmative. Project has been approved. Thank you very much for your patience. Yes, sir.
What's the timeline for complying with the conditions of approval?
Mr. Chair?
Yes, sir.
I can answer that. It's 1 year.
Well,
Basically, 1 year from today.
1 year, okay, so I don't have to worry.
Yes, Tim?
Well, this, I know, if, we just approved the project for Laurier Street, and I was paying attention to the fact that it was approved on May 22nd of 2008, and the plan was never signed for another year later, almost to the date. So they gave themselves a 1-year extension, sort of, by waiting until the last minute to get the plan signed. So then they have another year, so they actually got 2 years out of the approval. And I think we have to look at what we're gonna do with this in the future, so that we don't have 2-year projects out there that really have a 1-year lifespan.
Well, I think by law, there's a state law out there that they have a vested interest for 4 years, if I'm not mistaken, so.
Well, I don't know about the state law, but I do know that I couldn't understand why we were doing a 1-year extension on a project that was already 2 years old. So I'm just making that point for discussion, and I don't
Okay.
expect an answer on it.
You're not gonna get one. Thank you.
So you have 1 year, okay.
Next.
Thank you, Mr. Todd.
Thank you very much, members of the board.
Going back to our other agenda items, we have some other business issues, and there's been a very patient woman in the front row, and I'm gonna ask her what she's here for,
The sign.
because I don't know her.
The sign,
Number
probably.
5.
I figured it was the sign, but
It's the sign.
I want to beg the board's pleasure to take up her request for a sign for the Village Reflection Salon, which is on number 5 in your packet. Additional information tonight shows the location, what it looks like, and all those kind of good things, and Brian, what can you tell us?
Mr. Chair and members of the board, you have a report from Derek Horn, who has reviewed the sign and reviewed it against the zoning ordinance. He's provided us a short overview, and you have a picture of what the sign is to look like. This is for the Village Reflections Salon. It's to be operated at 10 Elm Street in the Village Commercial District. The existing sign is a pole-mounted freestanding sign that's internally illuminated. Current sign is about 15 feet high. The proposed sign has a maximum of 8 feet in height, as according to our current regulations. And this will be framed using the portion of the old Draper insurance sign. The proposed sign will measure 26 by 42, which is also smaller than the existing sign. So hopefully the sign will have less impact than the current sign that's on the property. It'll be illuminated using shielded external white light in accordance with the statutes. The Main Street design team has recommended approval, and they gave us a letter, and that's attached in your packet as well. And that's all I have. Okay.
Members of the board? Lowell?
Just a question for clarification. The intent is to take down the entire existing pole, right?
Yes,
Not this
I've
part.
been well made aware that everybody hates the
Yeah.
existing sign, including me.
For the record.
So, yes, we're taking that one down. The wooden sign that we're talking about is, the whole salon theme is
Yes.
gonna be, pictures of Goffstown Village between the 1700s and the 1900s, inside my salon. And so, I'm also trying to be a little green. Bob had an original sign 30 years ago, and that's the picture that's in your packet that he used before he put up that ugly metal thing, and I am going to reuse that.
May I ask your name, just for the record, ma'am?
Yes, Vicki Lovren.
Thank you.
So you can take the old sign, turn it horizontally?
The old, yes, I'm gonna turn it horizontally, so the scalloped part of it is gonna be
Sides.
here. And then, it's gonna be like a mailbox post with with like, downlighting on both sides, so that it doesn't shine up into the face of people, and it's just, cause I may be open till 9 o'clock at night, so I'm gonna use the existing lighting that's coming out there to that pole, but that pole is definitely coming down.
Okay. Barbara?
Nothing?
Tim?
It says here the applicant has not determined the overall height of the sign. So we have to be sure that whatever we approve tonight, that they maintain the 8-foot height restriction, which is mentioned in 6.7.5.
All right. Carl, anything?
No comment.
Okay. Does the applicant have any further comment?
No, the only reason I didn't know the height, cause I didn't know the requirement,
Okay,
but, so that's fine with
as
me.
long as you conform, that's all.
Yeah, there's a bush there, and I just wanted to make sure that if we sat in the car or an SUV or whatever, that we could see the traffic and the kids walking on the sidewalk.
Okay.
And I know that it's about a 5-foot 6-inch view that I've gotta clear, so
Okay.
I wouldn't go any more than, the 8 feet or whatever that the requirements are.
Members of the board? Someone like to step up? Tim?
I'd like to make a motion that we approve this application for this new sign based on the recommendation of the Main Street Committee and on the representation by the applicant.
Do I hear a second?
Second.
Okay, how many of you are customers? There's too many yeses over there. Okay. The motion has been made and seconded. Any discussion on the motion? And I'll move it. All those in favor say aye.
Aye.
Opposed? Abstentions? Motion carries unanimously. Thank you.
so much.
Thank you for your patience.
You're welcome. I was rather boring compared to everything else.
Okay.
Bye-bye.
All right. Last but not last, but next would be to reconsider condition 11 of the Sharon subdivision approval, map 9, lot 38-4, with town planner's recommendations, action needed, copies mailed. Members of the board. Very quiet.
Does
You
the
can see-
planner have
I wanna see what
anything on
Brian's
this?
gonna put up here before I say anything.
Well, he's gonna pipe in here in a minute.
All right, well, we're waiting for his pipe.
Okay, sorry, I had to back up a little bit. Okay. The applicants of the Sharon subdivision have been in contact with me requesting clarification from the board on condition number 11, which was part of the approval that was given to them, which technically was my numbering due, I sort of separated out Jim Raymond's comments from the minutes and gave the conditions that I found in there each a number so that it would be more clear in the report. Conditions 8 through 11, I believe, were the added conditions in the meeting. Let's see if I can find this.
In the packet that was mailed, it's 31.
Thank you. Okay. Yes.
Thank you, I was digging through.
So conditions 8 through 11 were each added to the project. Both conditions 9 and 11 are very similar in nature, and so the board may want to comment on both of those and perhaps clarify both of those, not just 11. But basically, condition 11 reads, effective immediately, the property may not be used for storage of material or for any business purpose, and any such material on the property shall be removed. Condition number 9 states, well, I didn't put that on here, states that the front portion abutting East Dunbarton Road shall have all fill material removed and shall be replanted to the planning director's satisfaction at the time of the sale of the first house. Now, you've got several pages probably of correspondence between myself and the applicants trying to interpret exactly what needs to be done on this property. My interpretation was that the fill material that's currently on the site, according to condition number 11, needed to be removed because of the language that says effective immediately. Any such material on the property shall be removed. The applicants understood that was not a requirement according to actually number 9, which I'll read it again. The front portion abutting East Dunbarton Road shall have all fill material removed and shall be replanted to the planning director's satisfaction at the time of the sale of the first house. So their contention is that there's somewhat of a conflict perhaps between those two. The way I read number 9, it didn't conflict. My interpretation of number 9 is that the front portion abutting East Dunbarton Road shall have all fill material removed, and that's kind of a pause or a separation from this next section and shall be replanted, so the replanting would happen at the time of the sale of the first house. So,
That's not how I got it. Didn't even-
Ms.
Okay.
So that condition in my mind is clear. However, the wording might have been a little bit better to separate those two thoughts. As far as condition 11, there was one other concern that the applicants had, and that was more their main concern, I think, that business uses were actually being restricted on this property indefinitely. And so they wanted to get that clarified by the board.
Okay. Tim?
As far as condition number 9, if I remember correctly, it was represented by the applicant that they needed the materials that are on that lot to use as fill material when they built the first house, and that's when they were going to clean it up at the time they built the first house. Now, I may have heard that wrong, but that was what I thought I heard. So, if the condition says that they have to clean the lot up when they build the first house, then that's what it says. It's simple. All the junk that's on the lot now has to be cleaned up and utilized when they build the first house, and then that lot needs to be straightened out at that time. As far as 11 goes, I think the effective immediately has been misplaced. I think the effective immediately was to stop someone else from using the lot as a parking lot right now. Someone has been parking some other equipment over there, or whatever the case may be. I do not think that the intention was ever to say that they could not legally get permission to use that as a business in the future. It was never meant to be like that. As far as the other part of 11, I don't think it was intended that they had to remove the material immediately. I think they kind of got crossed over, I think, in the discussion process here. And they are a little unclear, but I don't think it was ever intended to tell them they could not legally seek permission to use that as a business. I think it was to stop whoever was parking their equipment there or their trucks there as a temporary measure to tell them that they can't continue to do that practice. If that's what I thought I heard correctly at the meeting.
Barbara, you're thinking over there, I can see.
It doesn't happen often, so I can understand why you notice it, but, I mean, that's not how I recalled it, so we're
There you
probably
go.
gonna need to have, I mean, I thought it was, the discussion was that not only that vehicles were being parked there, that it was being used for materials, and things were going on and off the site, and whether the truck is parked there or not is sort of irrelevant as to where the materials are going on and off. Now, I mean, do we have a site plan for a business operation on this site? I mean, if we do, then that's one thing, but if we don't, I thought that was the point of this, was that there wasn't a business site plan. There, you know, you have rights to do a lot of things on your property, but as we know from another application we talked about tonight, you're supposed to get permits to do various things, and I'm not aware that anybody's referenced any permit for a business activity on this site. So I understood it more in line with what the planner has stated, so we obviously need to have another discussion. I do sort of wanna know, cause this certainly didn't, I had a chance to look quickly at this correspondence that's in our packet that was on the table tonight, in regards to changes and a proposed change. Was it here? Oh yeah, it was here on page 3. First of all, there's an allegation that this property that's on this site is, the town has put there. So I guess with Megan being here, I wanna clarify whether we're talking about a bunch of material that the town has just dumped and left there. 'Cause that's what it very clearly says. This material was placed on site by the town of Goffstown Public Works when it was looking for a location to dump material. And perhaps we're talking multiple piles here, so I think this was sort of in reference to by East Dunbarton as compared to where I understood some of the trucks were parking and there was other
Megan.
material.
Megan?
Yeah, I'm not aware that we used any stockpiling there. I can find out. I know we did have some work down on East Union, like a ditch line right there.
East Dunbarton.
East Dunbarton, sorry. East Dunbarton, right around the corner, there was some work that the town had done fairly recently, I think, where they went out to tune some stuff. What I remember at one of our meetings was, I thought the owner of the property said that either his neighbor or the guy across the street owns a landscaping business and they use it from time to time, and he had allowed that if he had some extra equipment, I thought the owner of the property said that, and I guess I thought that's what the condition was about.
Right.
That type of equipment, essentially, I thought the planning board was telling the owner, we don't want you allowing your neighbor to use your property for the other guy's business, you know, there should be no business use on there. But if you wanna park your boat there or your ATV, that's okay until after the first house is built, and then the excess piles and everything are being removed and it's supposed to be restored, I thought.
What I heard.
That's what I remember.
Mr. Chair,
Yes.
this letter actually came from Pat Panciocco, and she's in the audience, but she's shaking her head, so I'm a little, I'm a little confused.
She's looking to be
But
recognized by the chair
I
here in a
was
moment.
hoping that you might recognize her.
Any other board members
all
have
know
a
who she
comment before I open it up to public comment?
Well, my recollection is
Carl?
consistent with Barbara's, and the intent was that, you know, this parcel is being used to stockpile material, park equipment, on again, off again, on again, off again. We're trying to stop that until and unless they come in with a site plan proposal to conduct some sort of a business off that piece of property. Until then, clear the stuff off, stabilize it, and let it sit. And that's my recollection. I think it was clear as that.
Lowell?
Yeah, that's kinda like what I was thinking too, was the idea was the primary idea was to get rid of any kind of sign of the operation of a business there.
Okay. Bill?
Well, after the approval of this, I've driven by there many times, and I assume we're talking about the lot that has the track Komatsu parked on it,
No.
across the street?
The Komatsu's on one side of the road, the other side of the road is where all the boulders and fill piles are.
Which is the lot we're talking about?
The pile with the boulders, I assume, correct?
Yeah.
That's
Pile
on
with
the
the
opposite
boulders.
side.
Okay, well, I guess the thing that, my observation of driving by there is, I see even the track Komatsu, okay, on the right-hand side going by, I see, a pole, unit that holds, a salt spreader for somebody else. I'm just talking about what I'm seeing in the neighborhood, okay? I'm driving down through the neighborhood, and I see that operation on one side of the street. I see Dave Walton's demolition with all this other stuff out there for sale, all this other, I don't see this as an eyesore. I don't see this as, I mean, I see other things in the neighborhood. I don't even see this, so I just looked at it and I don't have an issue with it. That's my observation.
Well, I think the question is, what was our condition, not whether or not we have an issue today with
No,
something.
I understand that, but going by there, I'm looking at it as a condition that we put on here, and I frankly don't even understand why it's even on there as a condition.
Because it was part of a subdivision approval.
I understand that, but when you
But
go
you-
and you look in the neighborhood, I don't.
What are we supposed to do? Turn into the truck police and run around and tell someone they gotta clean? It's not our job.
Right.
Our job was to deal with this subdivision, and we dealt with this subdivision.
Tim?
Right.
Tim, please. Bill?
You asked me for a comment.
I know I did, I just put my foot in my mouth. I'll open it up to the public. Is there anybody in the audience wishing to speak references? Please come forward. And I know you're gonna tell us how to word this.
I'll try to be careful.
Okay.
We just want clarity. Pat Panciocco for the record, and Brian and I tried to resolve this easily and simply without having to bother the board, so thank you for taking the time to hear this. We really have no qualm about number 9. Number 9 is fine. We agree that was what was said. The concern we have is with number 11. The effective immediately has been discussed. We felt conflicted because, as you've already discussed, the material that's on there is gonna be used to develop the sites. It'll be placed, and that area will be reseeded. The material that's on there first became an issue with the Conservation Commission. And it became an issue because a little bit of it was a little too close to the buffer area. So we had silt fence put in and had all the marking put there, so it would be clear to the applicant exactly where that line was, where the material could not go beyond. That way, everybody was safe, they didn't have to worry, and he didn't have to worry about a problem out there. So that's where all that discussion came up. And at the time it came up, a member of the Conservation Commission, Mrs. Ricard, was really concerned about the material, concerned that a site contractor would be operating a business from the site, which isn't the case. As I said in my letter, the applicant allowed a neighbor who has one of those properties over close to Blackbrook to park a couple of pieces of equipment there during the winter because he didn't have another place to park it. And it was temporary. It's now on a job site now that we're in the construction season again. It's not there anymore. So to the extent that there'll be ongoing parking of equipment, that's just not the case. There will be equipment there again when the lots are developed and that material is placed. Now, as to the material and where it came from, the town had down at the bridge there, Megan, where they had the washout right next to that front street, the little
Pollard
bridge
Road.
there was a lot of boulders.
No?
There was some sort of washout there, and there was a need for material to be disposed of. Where they needed fill, they said, oh, bring it up here, we'll use it, it's clean fill. And it's been stockpiled there until the project was approved in some manner or form, and now it will be placed. It's not a business per se, but it was right up the street, it was convenient to put the material there until it could be placed. That's where it came from, that the town had the material in its possession at one time due to that washout. Now, as to the business aspect of it, the concern that we have is that there may be a heightened restriction placed on this particular property because of the way that condition 11 is worded. The applicant understands, as does anyone else who's expressed an interest in this property, permits would need to be requested from the town to operate any type of business from that site. Period. End of story. They can't operate a business until they come here and satisfy the requirements for proper permitting. But the way the condition was reading, it sounded like a covenant almost, that it was an enhancement above zoning, but I don't think that's what the board was intending. So hopefully that gives you a little more insight as to where we're coming from.
I was hoping you might have reworded that paragraph in an effective manner the way you wanted it.
Well, I did in my letter.
Oh, I don't agree with that, though.
Then you can change
Hold
it.
it, okay? All right. Members of the board, do we have any questions of the presenter?
Let's rewrite it.
Does anybody, in their opinion, have a better wording that meets both the applicant's desires and ours?
I don't have a better wording, but I have a comment.
Okay, fine, please.
It's sounding more like this is kind of like a misunderstanding that, you know, seeing, you know, this stuff on the site was mistakenly taken for a business operation. If that wasn't the case, then I don't think there's a real big issue.
Yes,
As long-
that's
as long-
fair.
And like you say, if this is gone now, and if it's not coming back until the site is developed,
Correct.
then
Barbara?
So I understand the representation that's being made. What Selectman Devanza drove by and didn't notice the other day, being facetious, what was there which you didn't seem to think was extraordinary given the area of town?
Well, especially when across the street, you got a big Komatsu on a track, and every other piece of property has construction equipment on it.
Right, I can't wait, well, that raises a whole nother question, but besides that, am I understanding that what I see there today will be exactly the same until the property is, the development on the property is begun? 'Cause that's what I'm hearing, is that it was just put there by the town, and I was on the board during Pollard Road Bridge reconstruction, and I don't remember DPW ever talking about the need to store lots of material off-site, but maybe it happened. So what I'm hearing from the applicant is that all of this is just for the development that we approved, the subdivision that we approved. So therefore, from my standpoint, you know, just as the observer, I'm thinking that then there would be no reason for it to be touched until development is undertaken. So I guess if that's the representation that's being made, I understand that. But I think that there were a lot of other issues that, you know, the board was trying to deal with as they come from the applicant and abutters and all that, when we were trying to do this, and that's resulted in what other people appear to think is a problem, so. Is that what the applicant is saying, that there'll be no change in these piles until development of this subdivision?
There's immediate plans to deal with that material in the works. I've advised the applicant to not touch anything until this matter has been resolved with the board, because we didn't want to have any other problems out there with the goings-on. The material that's out there is really, it's not a lot of material. It's certainly not what you would find in a commercial storage of material. And it was there taken from a site that's somewhere near. I can't say it was from Pollard. I think it was more recent. So I don't know exactly where it came from, but it was placed there because they needed a place to put it, and the applicant needs fill. So it worked well for everybody. It was all by agreement. But there is immediate plans to do some work there, and that will be taken care of.
I'd just like to, as the chair, make a comment. Are we saying that paragraph 11 basically should stay on development, and any business will require subsequent approval by the board? Is that what I'm hearing? In a kind of, in a nutshell kind of thing? Tim?
Well, I was gonna say that since the second part of condition 11 deals with material being removed, it's already been addressed in condition 9. So I would suggest we strike after the words that say any such material on the property shall be removed. We strike that completely because it's already been dealt with. I might suggest that the intent, what I felt was the intent of the discussion is that the property cannot be used for vehicle or equipment storage, either temporary or permanent, unless proper town ordinances are followed and or something to that effect. I don't know how to word it correctly. Jim would have worded it better than that, but I think
that's what's essentially in her suggested.
so, I mean, I think 11 should deal directly with the fact that the property had been used as an equipment storage area, and it's not to say that you can't have a business permit, but effective immediately, we don't want it to be continued to be used as an equipment storage yard for the neighbor. But we still have to take into account that the property owner has the right to store his own vehicles on his own land.
I think, if I may?
This is getting confusing.
Carla?
You guys correct me if I'm wrong, but I think what I'm hearing is that the fill material is gonna be removed and used for the development of the first lot in the new subdivision.
Correct.
So I would suggest that number 9 should read, the front portion abutting East Dunbarton Road shall have all fill material removed concurrently with the development of the first lot.
Which is what it says.
Well, no,
Because-
it doesn't say that,
Oh,
the way it's
doesn't?
written out.
Say that. Then we can get rid of the second half of 11.
Right.
And the first half of 11 goes without saying. I mean, our ordinance says you can't conduct a business without going through site plan approval. So I mean, that to me is a moot point. I mean, I don't know why we need to bring this into this as a condition, unless you wanna do it for some sort of clarity, but to me, I don't think we need 11 at all.
No, I agree.
I think we refine number 9 and get rid of 11.
You're thinking?
Collis, would you reread what you wrote for number 9?
The front portion abutting East Dunbarton Road shall have all fill material removed concurrently with the development of the first lot of the approved subdivision.
You know, I guess if the owner decides to let the neighbor park equipment on the lot in the future, it becomes a matter for the zoning enforcement officer and not for this board.
Exactly.
So let the zoning enforcement officer
Exactly.
deal with it on a complaint basis.
I agree.
Okay.
So if that's a motion, I'll second it.
I'll make that a
And
motion.
then you make a motion to eliminate 11 in its entirety?
And modify 9 as I suggested.
We have a motion on the floor, Nancy, by Carlos, seconded by Phil, to modify paragraph, condition 9, and effectively delete condition 11 in its entirety. Any discussion by the members of the board?
I can
I don't think you've resolved the problem, so that's all I'm saying.
Any further discussion on the motion?
So presumably.
Chair.
Yes, Brian?
I just have a quick question. Does the board still want to keep the condition that the property that has the fill material currently on it be replanted according to the planning director's satisfaction? Or,
That's in number 9.
Yeah, that's
Right.
in conjunction with.
That would stay.
but I wasn't sure if you were deleting
No,
that
no,
second
no,
portion
no.
of,
Oh, okay, yeah, to me, I thought you were.
No, I'm
saying
sorry. Yeah, the
that
rest of
was
it,
being
the
left
rest of
out.
it would remain.
All right.
Yeah.
Does the person who seconded the motion agree
Yep.
to leave in the planning director's satisfaction at time of sale? Okay.
How about, wait,
Wait a minute, the
at the
planning
time
director?
of construction of the first house?
yes.
All right, okay, at the time of construction, okay, fine.
Mr. Chairman?
Yes,
Why are we leaving it up to the planning director to decide if it was planted correctly? I always thought that would go to the Public Works Department or somebody else. Brian's got enough to do, is he have to go right around and look at planting jobs.
I think Megan has enough to do.
well, they can decide on who's buying coffee that day, and they'll go out and look
Right.
at it. Thank you.
Okay.
Any-
Planning director can reassign the responsibility.
True. Is that, any further discussion on the motion? Gonna move the motion. Effectively eliminating, condition 11 and modifying the contents of condition 9, as recorded by our secretary. All those in favor of the motion say aye.
Aye.
Opposed? Any abstentions? Chair's votes in the positive. Motion carries unanimously. Thank you.
Thank
for your
you.
patience. Do we have our last thing in terms of, we have the appointment of CIP members. Brian, what can you tell us about CIP? This is trial by fire, trial under
Him on
fire.
the spot.
But the conditions are, Tim said that they're a couple short.
Doesn't mean anything, we can keep going.
He's not the chair, he's the ex-chair, or soon-to-be replaced chair, or something like that.
Presumed chair.
Presumed chair.
Mr. Chair, Mr. Chair, do you have the paperwork in front of you, or?
That's why I will never be
did,
chair up there, but as long as I'm both.
I was looking for it, I didn't really see who was in the mix. But I would, and I didn't see anything in here for signature.
But the bottom line is that we need 2 at-large volunteers
Citizens at
for
large.
for the CIP committee.
So if anybody at home tonight is listening and wants to volunteer for CIP, come in and see Brian Rose in the planning office and he'll get you signed up. Thank you.
I
When do they meet him?
Next Thursday.
I do have it.
Okay, Mr. Chair, those paperwork are just basically the approvals that the board would give tonight for each member of the CIP to be a member of the CIP, and you know, approving who the chair would be and such and so forth.
Okay.
Didn't we done this on a voice vote in the past instead of, we didn't have to all sign the forms in the past.
All right. I'm gonna ask to see if, oh my goodness. I'm not so sure I agree with all these guys.
You're
Can,
nominated.
can,
Is it separate one for each person?
huh?
Two for each person.
If you don't
There's
agree with Tim,
three.
don't
There's
say it to
three
his
for each
face.
person.
Right,
An extra copy, just
Never
in case.
disagree with me,
There's
that's
an
a
extra copy
mistake.
just in case. I'll take a group nomination for Tim Redmond, Bill Gordon, Earl Carroll, and Henry Boyle.
Motion to appoint.
You done
Okay, and then I need a second.
Second.
that? Second.
Any discussion? All those in favor say aye.
Aye.
Opposed?
Me.
Abstentions? I will pass these around. There's a lot of signatures required. Please, start down there with, I have two others here for Fred Platt and Matthew Monahan, both who said that they cannot be members.
We still need a plan, we haven't got a budget committee representative signed up yet. Who's this board, who's our selectmen's rep, do you know?
I think it's Nick.
Nick? Okay.
Dick Capasano was in that
Okay, I didn't hear you say Nick's
batch.
name.
He's in there?
I didn't hear you say his name, I'm sorry.
Oh, we would be.
He's already,
He's already a
public
de
official.
facto member.
So
Yes.
am I.
You're getting me going here now.
Mr. Chair?
Yes.
I believe that that motion still needs to be made. That's what I heard from the town clerk at least.
Which motion?
For,
Nick
even
to
if,
be
even for the members of the committee that have been appointed by, you know, their own
Other
boards,
boards.
they should still be formally appointed by you because you're the governing board over the CIP.
And, amend the motion,
Well, there's not another motion.
I have a second motion to appoint Nicholas Capasano.
I'll
And
make
Sue
that
Tremblay?
motion.
Excuse me?
Was Sue Tremblay in the first motion?
Yeah, 'cause Sue's on committee also, she's a school board member.
Did I miss her?
Yeah, she's in.
Yeah.
Add Sue Tremblay,
So moved.
second,
Second.
all in favor?
Aye.
Opposed? Motion carries. Sign away.
Yeah,
Why don't you
so-
bring the hand those this way so we can start signing?
Oh, no, she's got them all. Barbara's got them all. She's good at signing things. Scribble, scribble.
I don't sign my own.
Takes care of that. Do you wanna update the board while the things are being signed, Brian, about any code enforcement officers and the conservation,
I don't know, does the alternate sign these?
situation at Flagstone
No?
Development Durango
I'll sign as
Drive,
an
or do you
alternate.
wanna just leave that as a matter of the record,
I'll
because
sign as an alternate.
you and the enforcement officer have agreed that there's no infraction of
He's a voter member.
wetlands or tree cutting or whatever,
Carl.
based upon the report I've read.
Just sign like I do, nobody can tell anyways.
Mr. Chair, I basically don't have anything additional really to add to that. Derek did go out and he drew you all a nice little colored diagram, which I hope you will compliment him on. He's probably gonna be a great landscape architect someday.
Okay, I thank you.
So he's the one that should go check on those.
Oh, on the replant?
Right.
Put him in charge of review.
Okay.
But yeah, there was no infraction upon the wetland buffer, and so we're determining that that is a non-issue at this point.
Any other action of the board that any member of the board wishes to bring forward at
Chair?
this time?
Mr. Chair?
Yes, Tim.
I would like to request that Brian look into something.
Okay?
We had a request for number 223 Blackbrook Road. It's a two-family house. I believe we had a request to make that into a condominium about a year or more ago.
Yes.
And we had a lot of conditions placed on the driveway and the culvert pipe. And I noticed nothing's ever been done over there, and I wondered if that that condominium request had been granted and the conditions had not been met. Do you know what I'm talking about, Meg?
I know what property we're on now, yeah.
So if you could look into it with Brian and see if they ever got their permission, because they've never done any of the
I don't
work.
think they have a permit
Well,
to do
if
any
they got,
driveway work, so.
well, if they got their condominium documents in place, which is what they were asking for, the conditions of that was to fix that driveway and the ice problem and the culvert and everything else. And I know that's never been done.
I know, I went out there during the winter, so I remember looking at the problem.
Maybe you could just check and see if they got their condominium documents filed or not. Or if they got an approval from the planning office or not.
Is,
Are you finished with those? Are you finished with those?
has anybody got any comments on timber cuts? We have 3 in the package for 49 Bog Road and,
One more.
map 4 lot 51-3, which is a Gene Walker property across from the Y. And map 6 lot 61 and 63.1, all submitted by the property owner through the harvester, which is, if I could read the, John Brown and Son.
I bet you the
It's
Gene,
49, it's 49 Bog Road, the Coughlin development that we approved.
49, it just says Robert Surratt,
No, then it's
oh,
not.
that's on the right.
49 Bog Road, I don't know where that
That's
is.
on the right, that's up past that. The two-family, I believe,
Okay.
across from Perkins. And I believe,
I just don't want another timber cut issued on an approved
I believe Walker's
subdivision
is all the blowdowns
lead
on
to
the
a
edge of,
cutting.
Edge of
of,
the road.
Yeah, the
Well,
rest of those
Uptown
are all
Back Road.
blowdowns. Some of those properties have got wetlands on them and, you know.
Any vernal
they're-
pools? No, just kidding.
Actually, I think there is one on one of them.
But it hasn't been
Give
before
these
for
to the chair,
subdivision.
If you have an interest in the properties, I have, the tax cards
I don't know.
and colored photographs from the, GIS here, if you'd like to look to see what those are about.
Okay.
And where they're about, and if you'd have any comments, Chair would certainly entertain those at a later date. Seeing no other business before the board,
make a motion to adjourn.
Second.
that was well. All those in favor say aye.
Aye.
Opposed?
And then we have to stop.
Thank
Our
you.
break now?